Good day to everyone. Welcome. So glad you're able to join us for an hour or so in order to talk about customs forced labor compliance and enforcement cases that your panelists have been quite involved with over the past several years. My name is Ben England with Benjamin L. England and Associates and FDAImports.com. We have a great presentation with three speaking panelists and then a question and answer at the end. So we'll have plenty of opportunity for us to hopefully get to as many questions as possible. I'm going to ask Jeff McConnell if he could step in and just give us a little bit of housekeeping for everybody so they understand sort of how this is going to work, and then we'll jump right into it. Jeff?
Fantastic. Thank you, Ben. I just wanted to go over a couple of quickies. The email, there will be an email of this video emailed, pardon me, there will be a copy of this video emailed to you in 24 hours automatically. The questions that you draft on the corner on your right side will be answered. If we run out of time, we will email responses to those, of course. And the presentation will also be made available at the same time. With that, Ben, I'm going to throw it back to you and enjoy.
Great, thanks. There is, of course, a chat box on the right-hand side. If you're viewing the chat box, you can minimize that so you don't have to look at the chat box. Jeff, there is a question about some people having maybe some connection issues, so you might
yes, I see
have
that.
a private chat with them to help them out. So we're going to do this in two parts. Benjamin L. England and Associates, FDAImports.com. We've been practicing at the FDA and customs intersection for a very, very long period of time. Our first speaker is going to be Jessica Rifkin. Jessica is the Customs and Trade team leader here at this law firm, and she's been practicing customs international trade law for many, many years, and has been leading our team in that respect. She has over 20 years of direct experience in customs and trade, and has specialized experience over the last several years in the area of forced labor. And we've been able to, along with Impactt, we've been able to have quite a number of successful cases with respect to withhold release orders as well as findings issued by customs. And so you've got people here who actually have been in the trenches and have worked through these kinds of cases. But in addition to forced labor, Jess also provides guidance on all other aspects of import and export processes and all the different areas in customs and trade law, including classification, valuation, free trade agreements, origin, as well as enforcement cases. But I'm going to pass it off to Jess, and then I'll introduce Jen and Rosie as we get into their parts. So Jessica, it's all yours.
Thanks, Ben. Next slide, please. Next slide after that. And after that too. Okay. Thank you everyone for joining us. Excited to talk about this topic. As Ben mentioned, we've had a lot of experience in it. So please, get your questions ready. We're happy to give whatever help we can. First, just like to start with kind of a brief overview of the forced labor laws here in the U.S. The basic forced labor law is 19 U.S.C. 1307, which prohibits the importation of any goods made in whole or in part with forced labor, which is defined in the statute as all work or service which is exacted from any person under the menace of penalty for its non-performance and for which the worker doesn't offer himself voluntarily. It also includes forced or indentured child labor. CBP looks to the 11 ILO indicators of forced labor to determine if forced labor has occurred. And those are things such as restrictions on freedom of movement, debt bondage, adverse working and living conditions, things like that. In addition to 19 U.S.C. 1307, as of June 2022, there is the Uyghur Forced Labor Prevention Act, the UFLPA. So now you need to distinguish between traditional forced labor and the UFLPA, which we'll discuss a little bit later on. Next slide, please. So what are WROs and findings? CBP implements or enforces forced labor restrictions through two means: WROs, which is detention orders, withhold release orders, which it issues when CBP has information that reasonably but not conclusively indicates that goods have been made with forced labor. It's an extremely low evidentiary standard that CBP has to meet, although CBP does do its own investigation generally before issuing them. Reasonable information to support a WRO can come from any source, such as NGOs, media reports, etc. Until a WRO is resolved, all goods that are covered by it are barred from entry to the U.S. The importer has 3 months to prove that goods that are subject to the WRO were not made with forced labor. And once it's been imposed, WROs are difficult to lift. The next highest level is a finding, which CBP issues when it has information that conclusively indicates that forced labor was used. For both WROs and findings, CBP does not give any prior notice to issuing them. The primary difference between a WRO and a finding is that goods that are subject to a finding will be seized upon arrival to the U.S., not simply detained. Like a WRO, findings are hard to lift, but they're even harder. Next slide, please. So what are some of the consequences of WRO? Practically speaking, there's tremendous supply chain disruption to both the producer, who's the target of the WRO, and to the importers whose goods are caught up in them. The fact that they're issued with no prior notice and have immediate effect means that many goods that are in transit, which could lawfully enter the U.S. when they were exported, are now going to be barred upon arrival. It's also quite difficult to prove, generally speaking, that individual detained entries were not made with forced labor and should be admitted. In addition, there are going to be, obviously, commercial disputes that are going to need to be resolved between the producer and the importer whose goods have been detained under a WRO. Next slide, please. So what can an importer do to protect itself? There's documentation to prove that goods that are not covered by a WRO, as opposed to trying to prove to CBP that your goods that have been detained were not made with forced labor, which is, again, very difficult to do. One avenue of possible relief is to try and prove to CBP that your detained goods were not subject to the WRO in the first place. So providing good documentation such as supplier affidavits, POs, invoices, proof of payment, and a list of production steps and other documentation. It certainly is possible to prove that the goods actually were not subject to the WRO and should be admissible. But this is the sort of documentation that the importer should already have on hand, or especially if you're importing a product that is potentially high risk, that you should have gathered beforehand. In addition, the importer, until goods have been seized under a finding, or until the 3-month period has expired, the importer always has the option to re-export goods that are subject to a WRO and that have been detained. Or, you can also divert goods if they are in transit and haven't yet reached the United States. However, when making the decision to re-export or to divert, importers should bear in mind potential restrictions in other jurisdictions. One common destination that importers that are subject to these restrictions have used has generally been Canada or Mexico. However, importers should bear in mind that Canada and Mexico have their own obligation under the USMCA to prohibit goods that are made with forced labor, and have at least started to implement those restrictions. Importers should also bear in mind whatever contractual remedies they have against the producer. For example, force majeure, consequential damages, if those are provided for in your agreement with your producer. Importers should also be aware that there are possible penalties for importation of goods made with forced labor. While CBP generally has not imposed penalties for violation of that restriction, they have said that they intend to increase their enforcement activity in that area. Next slide, please. What can the producer do? The producer can petition for modification or revocation of a WRO or a finding. A revocation is where CBP determines that forced labor was never present, and therefore the WRO shouldn't have been issued in the first place. A modification is where forced labor was present but has been fully remediated. Practically speaking, the difference between the two is that a modification generally is not retroactive. So that means that goods that have been detained under the WRO are not going to then become admissible once the WRO is lifted. The process is opaque, fact-specific, can be quite time-consuming. The most important decision that the producer can make when starting to engage in this process is choosing an independent third-party auditor whose results are going to be viewed as credible and reliable by CBP. A key part of the modification or revocation process is submission of audit results, which both determine whether forced labor was in fact present or is in fact present in the producer's operations, and also can demonstrate conclusively to CBP that whatever problems have been fully remediated. Next slide, please. So this is what CBP calls a slick sheet, which is just basically sort of a factual handout or summary that they've provided for the trade about what they expect to see in a petition for modification or revocation for both a WRO and a finding. And so it lists some tips for what they consider to be a credible audit, including that it's an independent third-party auditor, it's unannounced, interviews are done in the worker's native language, and while it's not there, it also should be outside of the presence of their employer. And then what they expect to see in a corrective action plan to correct whatever indicators of forced labor are determined to be present in the audit process. Next slide, please. Other points when submitting a petition for revocation or modification, the producer needs to be proactive and communicative with CBP. Generally, the producer, the target of the WRO or the finding, will retain both an attorney and the third-party auditor to help with the process. What CBP wants to see is a producer who is engaged, who understands that this is a serious issue, who's made a serious commitment to remediation, and who doesn't just kind of vanish in between rounds of questions, who is there to always proactively and thoroughly address CBP's concerns. You should also be prepared for follow-up on whatever you submit to CBP. I have very rarely seen a situation where you submit something to CBP and CBP says, great, that's it. CBP generally has a lot of follow-up questions. Be prepared to fully document what you've done. CBP requests all kinds of documentation generally, including remediation payments, actual bank transfers, pay slips, all kinds of employee documentation, other records. And be aware that in the event that a WRO proceeds to a finding, that's going to be even harder to lift than a WRO in terms of the evidence required, and also in terms of the additional administrative procedures that are going to need to take place before the finding is lifted. Next slide, please. So turning briefly to the UFLPA, We're not going to discuss that in depth today because that really is a situation where, in our view, remediation is really close to impossible. But I'll give you a brief overview today. Under the UFLPA, all goods that are produced in whole or in part in Xinjiang are presumed to have been made with forced labor and are therefore barred from entry to the U.S. The presumption also applies to goods that contain Xinjiang origin inputs, even if the downstream goods are not made in Xinjiang, which is, of course, a different concept for those of us who practice in the CBP area. Generally, you've got the concept of substantial transformation, where goods will lose their origin once sufficient processing is done to them in a third country. That's not the case with the UFLPA. Those inputs never lose their Xinjiang origin, and goods that were produced using any, at least in theory, using any level of Xinjiang input remain prohibited. The UFLPA also covers goods made outside of Xinjiang by Uyghurs that were forcibly transferred from Xinjiang, and also by entities on the UFLPA entity list. There are certain high priority enforcement sectors that are identified in the Act, which are cotton, tomatoes, and polysilicon. And more recently, CBP has given elevated attention to aluminum parts and PVC. Next slide, please. So under the UFLPA, really as a practical matter, UFLPA compliance has really turned into an exercise in supply chain mapping and tracing and documentation of the same. In theory, importers can apply for exclusions, which is importers demonstrating that goods that are subject to the UFLPA were not actually made with forced labor. In reality, even the Forced Labor Enforcement Task Force, the FLETF, says that state-sponsored forced labor, which is really what the UFLPA is addressed to, may be impossible to fully remediate. In addition, the Act requires CBP to publicly announce any exclusions that it grants and to tell Congress about that, which will make it public. So there's a lot of practical pressure against granting an exclusion. CBP would really be going out on a limb to do so. Out of the thousands of UFLPA detentions that have occurred so far, to my knowledge, there have only been 2 requests for exclusion that have been submitted, and those are still pending. If a detention under UFLPA occurs, the importer has 30 days to submit documentation for admissibility review, although that can be extended. There have been a number of requests for admissibility determinations, which is proving to CBP's satisfaction that the import was not subject to UFLPA. They have been successful. Importers that are subject to, that have detentions under the UFLPA, or really this is a step back, that have goods that may be subject to it, should consider using third-party testing to try and prove that the goods are not subject to UFLPA. Specifically, CBP has said that they may accept DNA testing or isotope testing of cotton in connection with apparel imports. And again, early communication with CBP is key. Next slide, please. Other countries. So under the USMCA, as I mentioned earlier, all 3 countries agreed that they're going to prohibit the importation of goods made with forced labor. Canada adopted laws several years ago implementing this obligation. However, Canada's laws function differently than the US's. They are not as stringent. The Canadian authorities need to have a higher burden of proof, higher evidentiary standard to impose import bans. And Canada has used this, to my knowledge, Canada has used this importation ban authority very sparingly. There have been several instances where they've prohibited the importation of certain apparel items. They did some prohibitions of Supermax gloves in connection with a supply contract for the Canadian government, but it certainly has not been as far-reaching as the US implementation has been so far. Mexico, to date, Mexico has not implemented the forced labor prohibitions, which it is supposed to under the USMCA. However, several weeks ago, there was an announcement that Mexico has adopted a resolution that's going to be effective this coming May to implement those prohibitions. Again, they're going to operate differently than the US prohibitions. Under the Mexican resolution, Mexican citizens or entities that are present in Mexico can submit petitions to the Mexican government to prohibit goods that are made with forced labor, or the government may self-initiate. However, unlike in the US, the government is supposed to inform the importer of the goods that are under review and allow it to submit relevant information prior to a ban going into place. The final decision is supposed to be due within 6 months after the petition is filed. Also, unlike the US, prior notice of the ban will be given. So you're not going to have that same sort of problem, at least in theory, where you have goods on the water that are caught up suddenly in a prohibition that was not present when the goods were shipped. There are other jurisdictions in which forced labor prohibitions are being considered as well. The primary one is the EU. It was announced last year, a kind of far-ranging prohibition that's under consideration. However, because both the EU still has to consider this, and the individual countries have to adopt it, it will be some time before it becomes effective, if it does become effective. And that is the end of my segment.
Thank you so much, Jessica. I appreciate it. We're going to keep moving right along here and go into part two. So part one, Jessica just walked through a lot of the legal and the regulatory and even the process parts of the WROs and findings for both the U.S. as well as identified some issues with respect to Canada and Mexico. We have some good questions coming in. Please keep the questions coming in. Don't worry about the fact that others can see them. There's no stupid question. We want to have a good, robust conversation at the end. I want to introduce to you to the next two speakers, and they're going to work in tandem. The first being Rosie Hurst. We worked with Rosie quite a number of times with respect to CBP, WROs, and forced labor. She's the founder and managing director of Impactt. She also founded CDEX and launched the Benefits for Business and Workers program. I like her sort of catchphrase that her vision is to make what works for workers work for business also. She's quite passionate about rehumanizing the workplace. We're also going to hear during this presentation, sort of in tandem, from Jen Janke. Jennifer is Associate Director for North America at Impactt. She hails originally having worked with Customs and Border Protection on the Forced Labor Division. So she has experience inside of Customs, after which she went to Amazon and then has since begun to work with Impactt exclusively. So I'm going to pass it off to the two of them and get out of your way and let them start.
Thanks very, very much, Ben. Can we have the next slide? Right, so we're going to get practical. We're going to talk about practically how to avoid and lift trade actions from our experience of working with Jessica and Ben and with others on actually the only two findings ever to have been lifted, in fact, and also one of the recent WROs that was lifted. Next slide, please. So we are at Impactt, we specialize in human rights due diligence and forced labor. So we're the people you come to when you suspect you may have a problem with this. One of our clients said, we use Impactt for the heaviest stains, which I always thought was a very interesting way of looking at it. But we're the people you come to if you need to find out if you've got a forced labour problem. Next slide, please. So we work globally. We're based in the UK. Obviously, we have a presence in the US, and we work all across the globe, specifically looking at issues to do with migrant workers and issues in workplaces with specific interest in forced labour. But now I'm going to hand over to Jen to talk a little bit more about what we do and how we do it. So I'll go on mute, but I'll keep my lovely face there for you, Jen.
All right, sounds good, Rosie. Thank you. So basically, as we're talking about the practicalities of trying to assess and address forced labor in your supply chains, we always start by suggesting that our clients conduct a risk assessment of their supply chain in order to identify areas of systemic risk. And as we're doing this, there's a couple of different ways to go about it. We recommend, first of all, that you put in place a proactive risk assessment into your overall forced labor due diligence program. And this allows you to really focus your resources on the areas in greatest need so that you can undertake credible programming. When we think about that process, one of the starting points that I often point clients to is the U.S. Department of Labor's list of goods made with forced labor, forced child labor, and child labor. Now, there are some limitations to the list. It is only updated every 2 years. And so it also isn't providing risk information at a granular level. This is at a country and industry level, but it's a good starting point in order to assess the risk that when you're looking at your supply chain. When we think about that, we do encourage our clients to think more in future in establishing North Star goals to create a more granular supplier-based risk assessment. And that's something we can discuss more in depth at a later time. However, when you start at that point, and you start looking at your country area of risk, that really helps identify areas where you may have vulnerabilities. And it may, in order to start that supplier and more granular level risk assessment, you want to start looking through at that country and industry level, and then you start moving forward. And some of the questions you may ask yourself are along this arrow here. If you have an activist reaching out to you, indicating that there is a problem in your supply chain, that is something to take quite seriously. In our experience, where there is smoke, there may very well be fire. It's better to assume that there's fire until proven otherwise, rather than to assume that there's nothing there and to dismiss what's being brought to you. The second thing to consider is that what your competitors are experiencing. If your competitor has an issue, there is no reason to think that you don't have that same issue unless you have undertaken a very rigorous process to rule it out. And so this is something that you should look at. To go in and to source from an area of risk without that robust due diligence component and investigation, you really would be leaving yourself open to regulatory risk. The third question that you might want to ask yourself is, in these operations, in your supply chains for the purposes of regulations in the US, are there migrant workers or other vulnerable groups? And if that is the case, that is certainly an area to look at. Migrant workers are at very high risk, regardless of the geography, of being pulled into a situation of forced labor. And it is something that needs specialized attention. As you continue your risk assessment, we really encourage our clients to stay away from or to not accept statements that say it's normal industry practice, or because quite frankly, there are a number of normal industry practices that actually do meet the forced labor definition. And so a number of times when we've spoken to suppliers, they've said, why were we targeted? Because everybody else in this area is doing the exact same thing. This is just how it's done. And yet here they find themselves in a regulatory situation where they may be the subject of a WRO, or they may be at risk of one. And that type of approach in thinking, well, everyone else is doing it, so I couldn't possibly have a problem, really doesn't stand up when you look at how the regulations under the Tariff Act of 1930, how that's been enforced. You really couldn't say that that was an effective defense. If you look at the next issue on the arrow, oh, yes.
I'm just going to jump in and say, you know, when you're driving too fast and the cops stop you, it's not a defense to say, I'm going the same speed as the other people on the freeway. So I think that's the kind of way of looking at that one.
Yeah, that's a really good point, Rosie. Thanks. So if you look at the next issue on this arrow, something to take into consideration is that if you have concerns, it's really important not to rely on other stakeholders to move forward. It's really important to start to engage with your supplier that's in an area of risk, and to start working constructively, perhaps in a collaborative manner, to try and commission an investigation and to move forward to ensure that you are not open or vulnerable to any type of regulatory action. Next slide, please. And that brings us to the next step in Impact's approach to this issue, and that is a diagnosis. Now, it's worth mentioning that there are a number of different terms that are used to discuss what needs to take place. But essentially what you're trying to do is identify whether forced labor is present within a certain scope, be it a supplier's operations or a sub-tier supplier in their operations as well. Any supplier that is involved in the production of a good that's imported to the US could be subject to a regulatory action, as Jessica previously mentioned. And so it's important to look at the sub-tiers of your supply chain down to the raw material. Now, I mentioned that there's a bunch of different terms that can be used for this. I would say that it's important to kind of differentiate and expressly talk about what you're looking for here. Audits, the term audits is bandied about quite a bit. And I would say, in my experience, a traditional social compliance audit is not going to sufficiently identify your risk if you're in a high-risk area. This is typically, these audits are done at scale for companies as part of a forced labor due diligence program, but the academic literature and media reporting are showing that these are not typically fit for purpose and should truly incredibly identify forced labor in your supply chains. And so we actually advocate for our clients to take a different approach. We suggest undertaking an investigation, a specialized investigation that takes a more intensive approach and a deep dive approach to identify the root causes of the forced labor if it is found, to take time to meet with workers, to interview them, and to learn about how they perceive their workplace surroundings, their conditions, both the working conditions and living conditions, and to better understand what's taking place at the work site. And in doing so, you want to look very much at not necessarily, there's a wide range of standards that are out there that you can assess a workplace against. But we suggest that you look very specifically at the ILO's forced labor indicators, because they are because that's where your regulatory risk is, and that is what CBP is using to investigate and determine if there is a violation of the Tariff Act of 1930. So I spoke earlier about then how you take those ILO indicators that you assess against them. And there isn't, say, a list with the ILO indicators of what each one means. And that's why it's so important to engage a credible social compliance subject matter expert, a forced labor subject matter expert who can guide you through that process. As it's also, we found very important to hire basically a provider who has a track record with CBP and understands how they view these issues. there is a different methodology that we use in these types of situations. It's more robust methodology. And I've spoken previously to the importance of engaging with workers to find out how they view their working conditions. And that's an important piece of any diagnostic process. Rosie, did you have anything to add here before I move on to the next slide?
Yeah, I was just actually going to say, I mean, let's be very clear here. CBP does not appreciate standard third-party audits. So CBP would not take as evidence that there was no forced labour a standard social compliance audit, which is why we very much promote the idea of a proper forced labour investigation. And we know that CBP takes that of evidence, as we'll see in some case studies we'll look at in a moment, that you have done your job properly in terms of due diligence, but also if you are unlucky enough to be under a trade sanction, they will take that as evidence of your improvement towards revocation or towards modification. And I think that's a super important point. Next slide, please.
Right. So we've talked quite a bit in reference the 11 ILO indicators of forced labor. And this can be a little bit misleading because you can have one indicator of forced labor, and that in and of itself could bring about a determination that forced labor is present. But if you also may have a situation where a worker is working in isolation, however, they are not working under abusive working and living conditions, they don't have any other indicators, and they are not being exploited in that position. Just by virtue of the fact that a worker works in isolation does not mean they're in forced labor. However, if at any time an employer uses that isolation in order to impose exploitative working conditions, pay, and any type of thing that would be adverse to the worker, at that point, then you're running into a very serious situation that would meet the forced labor definition. Typically, what you see is that in a given situation, you typically see what I could refer to as a basket of indicators. So if we refer to our example earlier of a vulnerable working group, I look at migrant workers as being highly vulnerable to forced labor. And so if you think about the migrant worker experience, they start off almost immediately being vulnerable, and they are vulnerable to deceptive recruitment process and possibly contract substitution. They may take out debt or sell family lands or property in order to fund this. And if they did that under deceptive recruitment practices, then you add debt bondage as a potential indicator of forced labor to that situation. Typically, migrant workers also find themselves vulnerable to retention of identity documents, specifically passport retention. And that's something that they run up against quite often. And if you, by virtue of their vulnerable status, they could definitely be susceptible to abuse of vulnerability. Say if they may not leave the work site if they feel that they're vulnerable to police harassment or incarceration due to their immigration status, and an employer could use that against them in order to exploit them. And that would also constitute a forced labor situation. So this is certainly not the limitation of how migrant workers may experience forced labor. They could experience any of these indicators, but that tends to be a basket of risk and indicators that I'm looking for when you have a situation where migrant workers have been brought to a work site.
And perhaps, Jen, we can just pick up the pace a bit because I think we're running a bit low on time. If we pop
Sure.
on to the next slide,
Yes.
just to give you an indication of what it actually looks like out there. This is a little peek into some of Impacct's findings. And you can see along the top there, Malaysia, Qatar, East Africa, South India, Dubai, Singapore, Taiwan, Philippines, and South Seas offshore. And you can see down the side the different indicators that Jen was talking about. And where the colours there show you the levels of risk of each of these things in each of these places. So I think we have to be very aware that risk is all around us. As I said here, expect a lot of tomatoes in your fruit salad. We often, once we go look in the high-risk places and contexts that Jen was outlining earlier, we do tend to find significant instances of forced labour. And I should just quickly tell you that red means that it's widespread, systematic in that country, and there's in that country and sometimes sector, and there's very little remediation, which means if you've got a red there in one of your countries of operation, that is something that you need to take very seriously indeed. Next slide, please. Let's move forward. This is the bit I like best, Jen. Tell us about remedy. This is about making it better.
Yes, absolutely. So in my experience, the best way to mitigate your risk here, your regulatory risk, is to fully remediate all indicators of forced labor. And I have not seen situations where there's really a shortcut around that. And so if you identify an area, a work site or an operator in your supply chain that has forced labor, we really encourage you to move forward with the urgency in order to remediate those conditions. And so there's a number of ways to go through this. And again, this is where it's really important to bring on a subject matter expert for forced labor to advise you on this, because there are the international standard for forced labor and the indicators are clear, but how to remediate them are not always clear. And that's where you need a trusted professional to assist you. Impactt has tried to address this in part by developing some guidelines that you may be able to reference as you go through your remediation process. One is the repayment of migrant worker recruitment fees and related costs, and the second is how to go about repaying wages in a situation where they have not been paid properly. And so to that point, we will continue to add additional standards. We're continuing to work on this. And in doing so, Rosie has really led the way on this. She has engaged with a wide variety of stakeholders in order to establish buy-in for these standards, and has consulted with credible international stakeholders who are engaged in this process, and hopefully will take it forward so that this is more established in the ways of operating in this space. As you go through your remedy plan in the corrective action plan that Jessica was referencing earlier, it's important to address these areas of systemic risk that we've been talking about. And the way to do that is to go through and to create internal controls and management systems that can credibly identify forced labor as it comes up and then quickly remediate it in a verifiable and time-bound way. That is a key point that isn't always clearly addressed. And we really encourage people to, as they're going through that diagnostic process, to identify the root causes, because that's what's going to allow you to then put in those management systems, which are absolutely crucial. Once a supplier has gone through this incredibly painful process, it's important that they're going to want to make sure that they don't have to go through this again. And regulators are going to be looking to make sure that those systems are in place so that when these one-off situations come up, then they're clearly remediated in again, a credible and time-bound verifiable way. And that way, CBP, in my mind, wouldn't want to revoke or modify a WRO only to find out that the conditions have returned. I think that's going to be extremely problematic for any supplier and importer that finds themselves in that situation. And just to take note of the other things here on the slide, it really is important that your verification includes information from workers. In the most recent trade symposium, I think they've called it something else now, but it's the annual summit that CBP hosts. There is always a forced labor panel, and on that panel, the U.S. Department of Labor's Austin Peterson referenced the importance of including workers throughout the remediation process. And so it's really an indicator of the importance that the U.S. government places on this approach. And so to that point, it is important that in those internal controls that you continue to incorporate worker voice. So,
Jen, I think we're running out of time. I just wanted to just nip through a couple of real examples to emphasize the point. Actually, this is from our very dear client, Top Glove. And if Melissa from Top Glove was here, she would say exactly the same as me. So she said, if they knew what they knew now, they would have acted much earlier on this. And I think all our clients who are subject to a WRO or a finding, it's a very traumatic process. Top Glove are to be hugely commended because they did exactly what Jess was suggesting at the beginning, which was they were very, very communicative with CBP, and they walked that journey together. They also published, as they went along, the findings of the various investigations and verifications. You can see here from left to right. It's also on our website. And as you can see, it took some time to clear up all of these issues, but by the end, they were scoring greens across everything, and their workers were confirming that. And I think that shows the amount of hard work that this takes, but it is possible, if you get hit by one of these sanctions, it is possible to get it lifted, but much preferable, Melissa would say from Top Glove, to sort the problems out before getting sanctioned. I just want to pop onto our very last slide, please, if I may, which is another very recent example from Sime Darby. And so we work with Sime Darby to support them. Obviously, they're a large plantation group. It's very complex to tackle this kind of issue right across tens of plantations, which actually it's actually hundreds of plantations and tens of thousands of workers. And you can just see here the number of things which Sime Darby did in order to solve their problems and also demonstrate to CBP that not only had they solved the problems, but if there was a recurrence, they would be able to sort the matter out as quickly as possible. And I just point to you to, of course, the reimbursement of recruitment fees, which seems to be a sine qua non for CBP. That is absolutely 100% necessary, and it needs to be done according to Impact's guidelines. That much is clear. But also things like helplines, controls for monitoring worker hours, development of apps so that workers can raise issues about their accommodation. And for example, there have been 37,000 requests relating to accommodation since October 2021. So it gives you an idea of the scale of work which Sime Darby have done successfully to lift the finding against them. So again, they would also say if they knew then what they'd known now, maybe they would have done some of this stuff earlier. And that is my parting words to you is, if you think you might have a problem, for goodness sake, take control of the agenda, find out what's going on, take steps to improve things. Because also pre-trade action, CBP may well have a look at what you're doing and decide to hit somebody else. I think that might well be true. Thank you very much, Ben and everyone. Sorry, we went on a little long there, but hopefully we can catch up now.
Yeah, it's not a problem at all. Jess, I'm going to invite you to come back on the camera. And while she's doing that, there have been a number of questions that actually have been answered in the chat box. So I want everybody to pay attention to that. I think that in the meantime, we'll probably, those will be available to you afterwards. Someone asked a question about the slides. So yes, the slides will be available. In fact, the video presentation will be as well. One thing I wanted to talk about is, so the Top Glove case, which you gave an example of, was a finding case. Sime Darby was a finding case. And of course, you know, I think when Top Glove, when that was lifted, it was 27 years since anyone had done that, since there had been a finding lifted. And so Customs at that time was a little unclear as to what the process was, because most of the people involved in the finding at Customs had since retired. So it made it somewhat complicated. And we were happy to be able to participate in paving that way. However, the finding is what happens when a WRO has continued to be investigated a lot of times because the company is not adequately responding. If you think about it this way, right? Customs comes out with their lower standard with respect to a WRO, and then there's some dialogue usually with the company. And if the company takes the wrong track, Customs is going to continue to investigate. And sometimes they'll use the information that they gave you in order to investigate. And if they keep investigating rather than stopping and responding to actually good substantive responses that the firm is presenting to the agency, if they keep investigating, they could end up at a finding, which is substantially more difficult to have overturned than a WRO. So early communication with substantive information, and it's not about denying that anything happened. It's about actually investigating it, actually coming up with some evidence, actually identifying who you've partnered with in order to actually address the questions. Those are the things customs is going to want to see. And I always think of it in terms of, I'm trying to actually stop customs investigation and have them engage with us instead, because then they're busy interacting with meaningful data and they're not continuing the investigation, and hopefully they're investigating somebody else. Otherwise, we could find ourselves at a finding, and that can happen. So let's look at the questions. We still have some time here. Let's see, those of you who have been keeping track of the questions, are there any that you want to jump out, that you want to respond to right now? I see Rosie responded to some, and so did Jess.
There is a question I'd love to have an answer to, actually, which is from Corey. He says, can a US customer that is not the importer but is engaged in the supply chain and has knowledge of forced labor conceivably be penalized for aiding a prohibited import? Yeah?
Legal question. Yeah.
Legal question. That's going to go straight to you, Jessica.
In theory, yes. To my knowledge, the CBP hasn't done it yet, but they continually, throughout the years, said that they are going to be more active in the penalty space. To my knowledge, the only one that they've publicly announced was a penalty on the importer in connection with the WRO that was subsequently elevated to a finding on stevia from China. So, and that was the importer itself, not, someone further down the chain. So, a customer that's not even the importer, that would be a stretch. But I suppose conceivably you could make an argument that they were aiding and abetting. So,
yeah,
we'll see.
Glenn had a question here too. I don't think it was picked up and answered yet. Is there a way to find out why specifically a shipment was detained? Sort of an active question in terms of the process. Will customs answer that type of general question when you have a detention?
So generally, the detention notice is extremely broad. It'll simply say you're detained under X WRO, or if it's a UFLPA detention, it'll just say UFLPA. You can and should, start engaging once you've received this. And, again, obviously, we recommend that you hire counsel to help you. With CBP, with the detaining officer, try to get it up to the C that's handling the detention, and see if you can get some additional information. Generally, they've been, pretty closed-mouthed about just how much they're going to tell you.
Yeah, there are two questions here that are sort of related. And one, I'm gonna go to the last version of it. Even after investigation, how do you know if workers are not being threatened to answer positively? And there's another version of the same question above, but I thought this would be one for Impactt to respond to.
Yes, thank you very much for that. And it's a very good question. I think that it's extremely important to be able to demonstrate that workers trust the third party that you're working with. So it's very important that the third party has direct relationships with workers so that workers can get in touch. If it's Impactt, get in touch with Impactt and speak honestly. They also need to see a track record of things improving when they make a complaint. So one of the things that CBP is very interested in, will ask for example, is pages and pages and pages and pages and pages of helpline requests and the results. And you need to be able to demonstrate that that helpline is both raising issues and resolving them. So in fact, CBP will not be that impressed if there are no complaints, because they will realize they're smart. They know these things don't just go away overnight. What they want to see is that the employer is tackling issues as they arise and is able to do that. So but building trust with the workforce is super important. Making sure that whoever you're using is very, very capable. So, for example, we have worker interviewers drawn from the same socioeconomic groups as workers. Some of them are formerly workers. They come from the same places as workers. They speak the same language as workers. And the interview is not a one-off. What happens is workers initially chat to our worker interviewers, but they often continue the conversation through WhatsApp or through helplines for a long time afterwards, and more information keeps on coming up, because this is a kind of dialogue, right? This isn't a one-off, you know, we did an audit on a certain day and it's fine. And CBP is smart, they understand that.
There's a question here that I want to pass off to Jen. It has to do with AI. And I'll tell you, having worked for the government, I worked at the FDA for 17 years, and we have 100 years or more former FDA experience in-house. And they use AI. In my experience, it's rarely artificial nor intelligent. And now that's typically sort of the experience that I've had. Customs, I know, is far more advanced, but Jen, I'll put you on the spot here a little bit. I know that you have to be careful about what you reveal with respect to your former employer, but they're not here. So I encourage you to share what you can.
Sure. Well, I think if you look at the most recent appropriation for CBP to enforce UFLPA and the Tariff Act of 1930, you'll see that there's significant funds that have been allocated for a trade analytics platform. And so it'll be interesting to see how that is brought in and how that affects CBP's enforcement of these different legal authorities on forced labor. But certainly, I mean, it's clear that CBP is looking in this direction. They have a technical expo that they are hosting in mid-March that is looking at this issue quite carefully. And so I think these are all indicators that if CBP isn't already using it, they will be soon. And so importers and brands need to look at what their current traceability and programming looks like, and make sure that they're not sitting back on their laurels, that they continue to advance so that they understand their risk before regulators do.
Great. I'm going to open it up for Jessica. I think we've covered all the questions. If not, we will definitely get back to anybody else who we perhaps missed. But any other parting shots from either Rosie or Jessica before we on the legal side and or the practical side?
Yeah. So just sort of a overview, sort of observation, just from looking through some of the questions. It's important to bear in mind that there's a distinction between what we've largely been discussing here, which is forced labor that is remediable, and the UFLPA, where you have forced labor that really, in the US's view, is not remediable because it's state sponsored. So the measures that that Impactt was discussing earlier about investigation, and then the crucial part about remediation, really go to more of sort of traditional forced labor enforcement, where you have WROs and findings and you're addressing them, which CBP is continuing to issue. Their pace has not been as quick as it was prior to the UFLPA being adopted, but it certainly is still continuing, and we expect it to continue. They've been staffing up. They've gotten a tremendous bump in the funds that are appropriated to them. They certainly have the capability, we believe, to continue to do enforcement in that area. Just as a small example, they've divided their investigations team at headquarters into East and West, showing they expect to do enforcement, not just, for example, in Asia, where that's been quite a focus, but, other parts of the world as well. So UFLPA is not the only game in town, but it certainly is a big game right now. That you're really looking at supply chain tracing and documentation. You're looking at how can you avoid having your goods detained? How can you avoid getting stuck in this problem in the first place? And if you are stuck in the problem, how can you prove to CBP that you've taken all of the steps that were necessary prior to engaging in this and your supply chain is clean?
Mm-hmm.
So, some of the remediation questions, I'm sorry, I'm looking at Richard's comments.
Yeah, no, I mean, basically, Richard's pointing out really what you said. Yeah, I mean, right, the fact that there have been detentions and releases under UFLPA because it was not actually applicable, which is a different question.
Correct.
That's where the traceability, the testing, the documentation demonstrates that we don't have, the goods are not from the region, or they're from inputs from the region. So that's right. Rosie, any sort of parting shots?
Yeah, I was just going to jump in on that to Richard's points there. Yes, I think because of the rebuttable presumption, because under US law, if it's from Xinjiang, it is made with forced labor. That's what the rebuttable presumption states. Really, all you can do is show it's not from that region. So it's about traceability, because it is impossible to meet CBP's requirements for investigation. So the stuff that we were talking about, so the level of due diligence, CBP believe that it is not possible to do that in China. So it's for that piece of legislation, the name of the game is traceability, and we do support our clients to understand where they may have risk and to carry out risk assessments. But the full due diligence that we were talking about, sadly, it's not possible, and we would strongly advise people to turn their view to the traceability aspects.
Good. So thanks to everybody who's participated, and thanks to everybody who's listened in. The last slide there has contact information for the subject matter experts, the SMEs. That was discussed earlier, the importance of having subject matter experts on your side, and we would encourage you to reach out to Impactt or to our firm, and we're happy to put our experience to work for you, whether together or separately. So the hope is that this has been very helpful. You will receive information about the availability of the slides, the availability of the presentation, Q&A responses, the questions and answers, and how that went. And of course, you'll be able to reach out to us. And unless there's anything else, I think that we're at time, and we can turn off, I think, as soon as we're ready to go. Jeff, anything final from you in terms of housekeeping? Or are we all good?
Housekeeping is perfect. As Ben said, question and answers will be sent out. Any other requests will be sent out as well, a copy of the slides. I want to thank everybody who hung in there with us and went through everything. I appreciate it greatly, and I hope you found this as informative as we all did. Thank you.
Great. Thanks all. Have a great day.